Yeah, please, Your Honour. Your Lordship. I've begged to mention item number 9, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship, due to personal difficulty of the conducting counsel.
On premier by the petitioner, this is matter after 3 weeks.
3 weeks. I do best, Your Lordship.
Please, Your Lordship, I beg to mention item number 3. Your Lordship, this is a connected.
Oh, number 3.
Yes,
I
Your
think
Lordship.
yesterday we had a.
Yes, Your Lordship.
Yes, Your Lordship, this is a connected matter with this.
Your Lordship, we would like to pray that it would be fixed on the 16th, which is the date which the case for yesterday is fixed. 16th of October.
It was fixed 16.
Yes.
Yes.
On premier by the parties, this is matter on 16th.
Lordship.
Item number 4. I have received a copy of their submission. They have supplied the copy to me. So I pray for some time just to have to go through and then I file my reply.
On premier by the petitioner, this is matter after 2 weeks.
Oblige.
Your Lordship, I beg to mention item number 5. I'm appearing on behalf of the respondent number 1 and 2. I pray the matter be listed after 3 weeks, Your Lordship.
This matter has not been heard.
No, Your Lordship.
But is this the matter connected with the one with pending?
This is the first inquiry. They have challenged the first
Reinstatement, Your
inquiry.
Lordship.
Okay. This CM of Milim or Langren?
Langren CM-ship, Your Lordship.
Cement company.
You are for respondent?
1 and 2, Your Lordship.
On premier by the respondent number 1 and 2. Not objected to by the petitioner. That is adjourned. List the same after 2 weeks.
Much obliged, Your Lordship.
Please, Your Lordship. I beg to mention item number 12, Your Lordship, the daily list. Your Lordship, with the petitioner this matter, Your Lordship, conducting counsel is not well, Your Lordship. He's hospitalized right now, Your Lordship. So if the matter can be kept after 3 weeks, Your Lordship.
On premier by the petitioner. This is matter after 2 weeks. Right.
Right, Your Lordship.
Lordship, I beg to mention item number 8, Lordship. So they are supposed to file the affidavit, Lordship.
May I please, Your Lordship, in item number 8, Your Lordship, I am appearing for the private respondent number 4 and 5, but Your Lordship, I am withdrawing from this case because so many text message, WhatsApp, call even, they are not replying for the last 1 month. So what to do, Your Lordship? Without instruction, I cannot appear just every day. So I am withdrawing myself from this case.
Let the matter call up. I'll pass this on.
Lordship, I beg to mention item 6, Lordship. Item 6.
Yes, you're supposed to file the status report.
No, Lordship, this is with regards to that SPV, Lordship.
Yes, that's what I said.
Lordship, as per the last date, Lordship, your Lordship has stated whether the issue is not with regards to the completion of the project, but then we have to argue on
Only on the point of whether the fund was
used from the SPV.
SPV or from PWD fund or government fund, whatever.
Lordship, I've just received the brief this morning, Lordship. I need some time to prepare, Lordship. Otherwise, the matter was being led by Mr. Swashish Sen. But then he's one next with held up in some matters with your Lordship. So.
And this matter is dragged for 4 years now for small issues. Yeah, Lordship.
The road is completed.
No, the road is abandoned by the contractor, and the project has not been completed.
Oh. Whether that will be an issue here, because you are concerned only about the utilization of the funds.
Yes.
On payment by the respondent, this is matter after 2 weeks.
Much obliged.
Supplementary list, item number 1. Please, Lordship.
Yes.
Lordship, if your Lordship will recollect, this is pertaining to that matter involving these Bangladeshi nationals, wherein they were granted bail and then condition was imposed that 2 shorties was needed. So out of those accused, my lord, one of the accused is an Indian citizen, and on last occasion I have prayed that I'll file an affidavit to that effect to bring a proof to show that he's an Indian citizen. So affidavit to this effect has been filed, my lord, and wherein we have annexed all the required documents like his epic card, his Aadhaar and birth certificate. My lord, there's also another development, a very unfortunate development. His mother has expired. Mother of the petitioner herein has expired on that day when we were moving that application, my lord, on the evening of 24/9/2024. So, my lord, there's a
On
slight
that day or
urgency.
yesterday?
No, on that date, your lordship, when we were moving in the evening, she expired.
Okay.
So that's why now there's a slight urgency also in this matter, your lordship, because he has to go and be with his family, if possible, to attend the funeral, or if not, also to be with the family.
See, Mr. Shila, the
Yes.
your case here is that the petitioner, even on
Yes, ma'am.
being granted bail, could not fulfill the condition. More particularly,
Yes.
more particularly as far as the surety part is concerned.
Exactly, my lord, exactly.
But
And on that,
if you are an Indian citizen, it can be presumed that you would have your relatives, you would have.
No, my lord, the problem is that I have a slight difficulty, my lord. The problem is regarding the fact that I am a poor person, my lord, and my family members are in Uttar Pradesh. It's difficult for them to come. Just the traveling fees and everything involves so much, my lord. And in fact, on last occasion, if I may recollect, my lord, I've placed judgment to that effect, where the Honorable Supreme Court has said that when it comes to poor people, certain relaxation can be given. And in fact, the learned counsel appearing for the government also at that point of time have conceded to the effect and have placed a judgment supporting my contention also, my lord. He has placed some judgment. I'm quite thankful to that effect, that he was very frank and candid in admitting this fact, my lord. So far as this Indian citizen is concerned, my lord, as we have submitted on earlier occasion also, the law is quite clear to this aspect. If it's poor and all, not perhaps this condition of sureties done away with, because that is as per the parameters of law, right from the judgment of Mutiram in 1970 and even the recent judgment of the Honorable Supreme Court also. So, my lord, I pray that if he can be released on PR bond, or maybe cash deposit of some small amount, my lord, because there is also another way of modifying this condition by imposing cash deposit of a small amount, so that he can be released, especially in this time of need. My lord, I'll place those judgment again, my lord.
Where are those
yes, my colleague is there, my lord. There are 2 judgments. One is of Mutiram, which I have placed. My lord, will have Mutiram case, 1970. This is a case where a mason was granted bail, my lord, but there was condition imposed for sureties, and he was not able to provide sureties, and the Supreme Court has released him on PR bond, my lord. And they've also explained the law relating to the modification of bail. My lord, we'll see paragraph 23, 24, and 25, my lord. It says a semantic smoke overlays the provision of bail in the code and prisoners' rights when cast in ambiguous language become precarious. Where doubts arise, the Gandhian talisman becomes a tool of interpretation. Whenever you are in doubt, apply the following test. Recall the face of the poorest and the weakest man whom you may have seen, and ask yourself if the step you contemplate is going to be of any use to him. Law at the service of life must respond interpretatively to raw realities and make for liberties. Primary chapter 33 in the Notice of the Law of Bail, section 46 of the Code speaks of bail, but the provision makes a contradistinction between bail and own bond without sureties. Even here, there is an ambiguity because even the proviso comes in only if, as indicated in the substantive part, the accused in a bailable offence is prepared to give bail. Here, bail suggests with or without sureties. This is very important. It says with or without sureties, and bail bond in section 436 covers own bond. Section 437(2) bluntly speaks of bail, but speaks of release on bail of person below 16 years of age, sick or infirm people and women. It cannot be that a small boy or sinking invalid or Paradhanishin should be refused release and suffer stress and distress in prison unless sureties are held onto a far-off court with obligation for frequent appearance. Bail there suggests release, the assent being an undertaking to appear when directed, not on the production of sureties. But Section 47(2) distinguishes between bail bond and bond without sureties. Section 445 suggests, especially read with the marginal note, that deposit of money will be duty with or without sureties. Section 441 of the Code may appear to be a stumbling block in the way of the liberal interpretation of bail as covering own bond with and without sureties. Specifically viewed, it uses the words bail and own bond as antithetical if the reading is literal. Incisively understood, Section 441 Clause 1 provides for both the bond of the accused and undertaking of the surety being conditioned in the manner mentioned in the subsection 1. To read bail as including only cases of lease with sureties will stultify the subsection, for then an accused released on his own bond without bail, that surety cannot be conditioned to attend at the appointed place. And my lord will see that in section in paragraph 34, paragraph 34. Here, the High Court, Supreme Court has released this person without any surety. We mandate the magistrate to release the petitioner on his own bond in the sum of rupees 1,000.
Yes.
In fact, the learned counsel of the state last occasion has also produced one judgment, my lord, the latest judgment, which is in line with 1917, Lord.
Yes.
Here also, person has been released on PR bond.
Let us hear Mr. Sengupta what he has to say.
My lord, I have received the application bringing on record the identity card of the petitioners and all. My lord, what I pray at this point, my lord, is that let the IO be given an opportunity to look into the documents, because it seems an Indian citizen has been wrongly booked under the, and whatever is the response from my, let me obtain an instruction from the IO concerned.
That is beside the point.
No, because the documents has to be verified, my lord.
Affidavit has been filed.
Yes,
What
absolutely.
is an affidavit?
Correct, my lord. But what I humbly submit is that, my lord.
An affidavit binds the opponent.
Absolutely, my lord.
Factual, you see, contents of such affidavit.
Correct, my lord. But my IO is, it seems my IO is ignorant of all these documents, and when granting of...
It is incumbent upon him to investigate.
Even in the trial court, my lord, when the order of bail was being issued, it seems they have not produced any documents saying that they are actually an Indian citizen. So this is for the first time these documents are introduced. Let my IO get 2 days time, my lord. 2 days time, my IO will file a response to this, and upon instruction, I have no real objection.
Have you got a copy of this?
Yes, my lord. I will forward it to the IO concerned through the SP, and thereafter obtain instruction, and my lord can pass appropriate order.
You seek instruction, we will take up the matter at 2 o'clock.
At 2 o'clock, my lord, it will be from...
Yes.
Item number 2.
And my lord, this is...
Item number 2.
My lord, this is not the first time that I produced this document. Even before the session court also we have produced, my lord.
Let him take the instruction.
Yes, my lord. But
yes.
the order of bail, my lord, did not at all.
You just seek instruction and see. You can always call him over the phone.
Yes, my lord.
Yes.
Either we do it at 2 or at the end of the board. It depends on you.
Yes, my lord.
Yes.
Yesterday one of the bed also came up. I think that one.
Who's appearing for respondent 4? Is it?
Well, I am there for respond number 4.
You have replaced Mr. Kriam. I think Mr. Kriam was in this case.
Mr. Krim, yes, no, in this particular
Krem
case,
is
I
for
think.
he had Mr. Krem was assisting me in this matter. That's it.
Yes, what was the issue yesterday?
But the matter of the 7 localities, so-called claim themselves as a village, came up before district council, and clubbed to all the entire petition was were clubbed together and heard together, and passed an order. And we challenged the impugned order, having the impression that only single order is there. So when we filed the case, then the special counsel brought the lordship notice that separate order also there. So other side, my learned friend, other side, they file application to strike out their names in the main writ petition. So lordship struck out the name, and lordship given us the liberty to file a separate petition challenging separate orders on the same day, same issue. So we filed a separate writ petitions. Matter came up together all along with, and my lord, the last occasion in 1 of July, there is a special counsel has pointed out that yes, before challenging the impugned order, the writ petitioner here, my party has filed representation to relook into the matter, because the view of the petitioner is that once the district council took a decision earlier, you have no power to review. So relook into. Before disposal of that representation, after waiting 6 months, nothing happened, therefore we file like this. Therefore, learned senior brought lordship notice that representation is still pending there. Therefore, writ petition appears to be premature. In view of that fact, my lord, all the parties, including me and my friend's side.
No, not me.
But my friend was not there. Friend was not there. My learned friend, Mr. Krem, representing my friend party, respondent number 4, 2 consented. Yes, it is similar issue. Number 1, the order has been passed, and my lord, representation is still lying there, and the submission of the learned special senior counsel was supported by him also. That is premature. So therefore, lordship have the view that during the pendency of the writ petition, district council may open that representation and dispose of, and allow all the parties to participate there. And whoever is aggrieved, either from my side or my friend's side, aggrieved, forum is open. My party may take appropriate action.
Well,
So in view of that, let me just complete. In view of that, lordship passed the order, allowing the district council to open the representation, allow all the parties to participate there. Now, the lordship's order is reflected in the first writ petition. It was not reflected in the subsequent writ petition, including the petition number 190. But what happened, thereafter, district council issued notice to all the parties for fairness, for transparency. What happened, the writ petitioner number 190 has filed a writ appeal, saying that without hearing us, I was not a party. I was not a party in the writ petition where lordship passed the order. So the order was passed, which is aggrieved by us. So we are filing a writ appeal with the leave of the court. Separate application also filed along with the writ appeal. So, however, lordship, Honorable Chief Justice acting, Justice thank you recused himself, saying that from the beginning I did not handle this matter. Therefore, matter went to lordship bench. So we will not take up. This is the situation now. My friends say that we are not a party. My friend was not here. Whether if my submission is correct or not, the impartial party is special counsel, special senior counsel is here. My lord, that was the situation. Therefore, my prayer today is whether, my lord, the representation is correctly filed or not, district council has seized the matter. All of them are participating in that process. Allow the district council to take a decision. Well, if I am aggrieved, I will take appropriate action. If my friends are aggrieved,
only submitting before your lordships is the foundation of the submission of my learned friend seems to be, my lords. And if that is correct, that his writ petition is premature. If it is premature, my lords, and he wants a prayer that the district council should dispose it of, let him withdraw the writ petition. We cannot blow hot and cold at the same time, my lords. I will press the matter before your lordships also, and I will say that let that matter be disposed of. That cannot be permitted. That's one. The second aspect of the matter, my lords, is a question of judicial propriety, as your lordships will kindly appreciate. Some orders have fallen from your lordships, my lords. One of the parties is aggrieved by that order, and it is an admitted position, my lords, an appeal has been filed. Now, due to some difficulty with regard to the constitution of the bench, my lords, that appeal could not be taken up. Now, with the notification of, my lords, new Honorable Chief Justice being, my lords, appointed insofar as Meghalaya High Court is concerned, I would only pray your lordships have this matter after a week. my appeal is going to come up, my lords, if whatever orders...
You have filed the appeal.
I have filed the appeal. I have filed the appeal. The two aspects, my lords, because we are saying that once district council takes a decision in a matter, my lords, they become functus official. So it is not open for them to re-look into a decision because they are discharging adjudicatory functions. They've adjudicated on an issue. That matter is an appeal before your lordships. If my learned friend says, my lords, that I want to press my representation, then writ does not lie.
That was not my case.
He is not doing that. What he's saying is, my lords, let the writ also continue and pendency of the writ shall not be a bar for the representation to be disposed of. That, my lords, may not be the correct thing. So I am only praying, your lordships may kindly have this matter after a week. Hopefully within a week, my lords, my appeal will be heard. Whatever orders follow, my lords, will be there for your lordships.
Yes, that would be one aspect of the matter.
My lords.
The only, confusion,
my lords,
rather, that has arose in these proceedings is the fact that this court has passed a comprehensive order in
the first writ petition.
Whereas there are a number of related
six other matters,
all identical.
Lordships.
So that is where the problem lies.
My lords, which is why I say that any order that flows against the order which your lordships have passed, my lords, because that order is under challenge before the division bench. So that would have a bearing on this also.
Mr. Sangresu, you think about it logically. If that order is challenged, any order passed by the division bench would also be applicable to the other, related petition, whether such cognizance have been taken or not.
My lord, my humble view is that, my lord, since he has filed appeal in one writ petition, if the appeal is any order passed by the division bench, it will confine to that one only. I cannot argue the merits of the appeal here. Only, my lord, I point out that, my lord, my friend was not there. Consent was made by all the parties.
No, my lords, my consent is not there. Your lordships must see the order.
There was no objection. There was no objection on that day. If any objection raised, lordship could have recorded.
No, that issue will be.
It was consent.
That issue will be agitated before the division bench.
Well, it's a question of propriety, I would say.
Now,
lordships, it has been brought to your lordships' notice that the matter is already in appeal.
Now we are taking up this matter.
My lords, this is 190.
This is 190.
My lords.
This is where the crux of the problem lies.
My lords. Because it's not in dispute, my lords, that all these 7 matters are all interconnected.
Yes, true. That's
so any order passed in any proceeding, my lords, would have a bearing on the other matters.
There is also a subsequent order by this court.
My lords.
Wherein that order
has been made applicable.
Has been made applicable.
In the other matters.
So that also has to be,
Well, in essence, everything then falls for consideration before the division bench.
Exactly. That would also be.
But when other parties
I am only saying, my lords, heaven will not fall in 7 days.
The other side cannot, my lord. One locality cannot carry the cost of entire six villages.
Oh, that is a different thing.
That's on merits, my lords. I am saying that
your
lordships may have this matter after 7 days. Whatever orders flow, my lords, your lordships will then pass an order. My appeal might be dismissed also.
They could have objected when.
If what my learned friend is saying that there is no objection, then my appeal will go.
With relooking of the representation by district council, they could have objected. They supported the submission by learned senior.
I am disputing this submission made by my learned friend.
The propriety, I will argue.
That would be decided by the division bench. Let division bench decide it. Lordships may kindly have this matter after a week.
Yes, I think we'll do that.
Well, I have no problem. Only concern by Lord, the district council may proceed. Other matter, district council hopefully will proceed.
No, difficulty with the district council is that
as long as there is no stay of this court order, that order will be enforced. Until other, if a subsequent order comes, then they'll be up to the parties to
Absolutely.
But the matter come up
after the puja vacations.
Made by the parties, list this matter after puja vacation.
Yes, I'm obliged.
Hah? Empat dep teh dang kawai dang. Oh, ya ayo dah macam mana? Telak kaki dan. Tapi saya layak kita minta perempuan. Também deixa eu pegar minha. Sebut nak ni apa Ifi? Saya. Akak. Hah? Untuk item item 4. Data.
Yes. Any mention?
Please, Your Lordship. Lordship, I beg to mention items number 4, 5, and 6, my Lord. They're all connected matters. It's a criminal appeal. Lordship, I pray for 2 weeks' time, Lordship. I've already informed the senior advocate, the counsel for the appellants.
This is out of the same
judgment, Lordship.
On premium by the state respondent, on premium by Ms. Anjishala, the senior advocate, senior government advocate, seeking for accommodation. The same not being objected to by appellant, matters adjourned. This is the same after 3 weeks.
Much obliged, Lordship.
4, 5, and 6.
Please, Your Lordship, I am too late. Admission.
Please, Your Lordship, I beg to make a mention of item number 2 on the daily cost list, Your Lordship. Lordship, I am seeking an adjournment of 2 weeks, Your Lordship, since the conducting counsel is indisposed.
No objection, my lord.
On premium by the appellant, this is matter after 3 weeks.
Highly obliged, Your Lordship.
Hello, if I may please mention item number 1 on the supplementary cost list.
Yes.
Hello, the senior counsel representing the respondent, Mr. N. Venkatraman, is on his legs and unavailable today. He went to the ASG and is representing the union in a matter. May I please request for a adjournment?
We'll take it up after vacation then.
Yes, my lord.
Okay.
May I request any date about any time between 25th to 30th October?
You suggest a date.
29th October, my lords.
29th October is fine.
On prayer made by the learned counsel for the respondent seeking accommodation on grounds of personal difficulty. The same not be objected to by the appellant. Matter is adjourned. As agreed to by the parties, list this matter on 29th October.
Very grateful.
Obliged, Lord.
May I please, Your Lordship? Your Lordship, I beg to mention item number 3, Your Lordship.
Therefore,
For the respondent number 4 and 5, Your Lordship.
I'm appearing for the appellant, Your Lordship.
who's 4 and 5?
Private respondent.
They're the private respondents, Your Lordship.
Private respondent.
I'm for the straight.
Why have you arrayed private respondents here? You have come against a
Judgment and
order of
Your
order
Lordship.
of conviction.
Yes, Your Lordship, 20 years imprisonment.
So why are private parties involved?
It's a sexual offence.
Your Lordship.
You have made complainant party.
Yes, Your Lordship.
If it pertains to bail application, maybe, but appeal, because even you see the complainant would be allowed to join proceedings
Your Lordship.
in the trial to assist the prosecutor. But once that is done, and in appeal, it is the impugned judgment that is assailed. So what role would they have to play?
Your Lordship will seek some clarification.
Please. I thought you were pointing out some law. On pre-made by the learned counsel for the appellant, matter is adjourned. This is here after 3 weeks.
Prayer made by the respondent, Your Lordship.
Pre-made by the parties. You have also sought for
Your Lordship. Highly obliged.
meet by the parties. No?
From daily list, item number 1. Daily list, item number 1.
Excuse me. Good afternoon.
Yes.
Ashmir, so this application has been preferred on behalf of an accused who is undergoing trial in Nongpo. He is involved in a commercial quantity matter, of course. Commercial quantity of heroin was seized in connection with the incident case. 70 soup boxes, around around 732 grams, which falls under the ambit of commercial quantity. So this is the third bail application being filed on behalf of the accused. First time before you, good sir. It has been rejected 3 times before, I think, in the Honorable Trial Court. Now, although it is a case of commercial quantity, Your Lordship, I have contended that there have been serious faults made by the investigating agency which have prejudiced the accused person. So that is the bone of contention which I have raised. Because I had raised these issues before the trial court itself, but they were rejected.
If you have raised such issues before the trial court.
One issue. This, and in addition to that, I've raised another issue.
Because see now, what is the stage of the case?
Sir, Lordship, it's at the stage of CC, consideration of charges.
Oh, CC.
But Your Lordship, these...
So charges have not been framed?
Not yet, Your Lordship. If I may take you to the lapses which have been made by the investigating agency, mentioned specifically in page 9 of the petition. Sorry, page 5 of the petition. Page 5, Your Lordship.
Yes.
Before I start reading from the petition, Your Lordship, I must actually inform the court that in the year 2022, in the month of December 2022, new sampling rules were framed.
Yes.
And they were published in the official gazette in the month of December 2022. They are known as the Narcotic Drugs and Psychotropic Substances Seizure, Sampling and Disposal Rules.
Yes.
Of 2022. So, Your Lordship would remember the standing orders of 1989 and 1988. So they're in consonance with them with regards to as to how the sampling procedure is to be carried out. Now what has happened, Your Lordship, in this instant case, 3 main rules have been violated of the said sampling rules. I'll refer to them as the sampling rules of 2022. Paragraph 9, Your Lordship. I've quoted in paragraph 9, I've quoted rule 3 of the sampling rules of 2022.
Yes.
Alright, if I may be allowed to read, I'll just read. Rule 3, classification of seized material. The narcotic drugs, psychotropic substances and controlled substances seized under the Act shall be classified based on physical properties and results of the drug detection kit, if any, and shall be weighed separately. Rule 2, Sub-Rule 2, sorry. If the narcotic drugs, psychotropic substances and controlled substances are found in packages or containers, such packages and containers shall be weighed separately and serially numbered for the purpose of identification. Lordship, what has happened in this instant case? That 70 soap boxes were seized. And let me take you to Sub-Rule 4. Yes. The continuation is Sub-Rule 4. The classification, weighing, packaging and numbering referred to in this sub-rule shall be done in the presence of search witnesses, panchas, and the person from whose possession the drugs and substances were recovered, and a mention to this effect shall invariably be made in the panchnama drawn on the spot of seizure. But if you look at the panchnama, Your Lordship, we'll find that no such mention is there. That is one point. Besides that, Your Lordship, Rule 9 has also been violated. I've just quoted Rule 9 below that, Your Lordship. Rule 9, samples to be drawn in the presence of a magistrate. Rule 9 of the sampling rules of 2022.
Yes.
Okay. So Rule 9 says, after application to the magistrate, samples to be drawn in the presence of a magistrate. After application to the magistrate under subsection 2 of section 52A of the Act is made, the investigating officer shall ensure that the samples of the seized materials are drawn in the presence of the magistrate and the same is certified by the magistrate in accordance with the provisions of the said subsection. Now, Your Lordship, as per the charge sheet, what the charge sheet says in paragraph 15, I'll take you there as well. It says that the samples were indeed drawn in the presence of a magistrate, but this particular rule requires mandatorily for the investigating officer to also obtain a certificate certifying the correctness of the samples drawn. That has not been done, and neither is there any mention about him writing to the magistrate as is mandated under this rule. Let me take you to the charge sheet, Your Lordship. Charge sheet, the relevant paragraph is paragraph 15. It is at page 36, Your Lordship.
Yes.
Page 36, paragraph 15. So this is the only paragraph which talks about the samples being drawn. If you look at the other paragraph, which is just preceding paragraph 15, it talks about police custody being done. Then paragraph 15, I'll just read the contents of paragraph 15. On the 10th of July 2023, the extraction was done before Srimati DMK Shadab, Nongpo, Ribhoi district. Firstly, the seized exhibit containing the seized contraband, marked as Exhibit A, was cut open, and accordingly an empty transparent plastic was weighed with the help of the electronic weighing machine of the NDPS kit, and the weight came out to be 0.76 grams, and the seized contraband were transferred from the master packet, which is marked as Exhibit A, into the empty polythene bag for 5.42 grams, and it was weighed, in which the total weight came out 6.18 grams, and the plastic containing the weight contraband was sealed and packed in an envelope and marked as Exhibit A1, which is the sample sent for expert opinion. The paragraph after that, Your Lordship, speaks about duplicate samples being drawn. So this is the only paragraph which speaks about the sampling process, which is in violation of Rule 9, which I just read out, Your Lordship. Why? Because he never wrote an application to the magistrate asking for certification of the samples, and neither did he obtain a certificate certifying the list of the inventory or the list of the samples so drawn. And one more aspect, Your Lordship, Rule 10 has also been flouted. Your Honor would be conversant with this particular rule. It's just quoted in page 7. Page 7 of the petition. Page 7.
Yes.
Page 7, I have mentioned, Your Lordship, Rule 10, drawing the samples. Now, Your Lordship, this particular rule is in consonance or paramateria to the rules, to the standing orders of 1 by 88 or 1 by 89, wherein it was mandatory for samples to be drawn from all packets. And this Rule 10 also says, one sample in duplicate shall be drawn from each package and container. Now, that has not been done in this instant case, because when the seizure was made, the contents of 70 soap boxes were emptied into one plastic, which was marked as Exhibit A, and it is this very packet which was placed before the magistrate for the purpose of drawing sample.
Tell me, Mr. Yadav.
Yes, Your Lordship.
From whose possession was the alleged contraband?
From nobody's physical possession, Your Lordship. It was recovered from a farmhouse. Now, what had happened was, I'm sorry, I should have actually spoken about that as well.
How are you connected?
Right. How was it connected? Because I was along with the accused, from whose farmhouse the contraband was recovered. Nonetheless, I do not raise those issues. What had happened was an information was received by the Nongpo police station.
So you confine yourself to your complicity or non-complicity as far as the case is concerned.
Correct.
Because if this alleged contraband was not seized from your possession, this going through the process of whether the sampling done was proper or not, whether rules was followed or not, that would be immaterial too.
I understand that, Your Lordship. I do understand that. But since the case at present stage is at the consideration of charges, it's at that stage. So it is open for me to raise that issue there.
Yes,
However,
you can. Yes,
no,
as you rightly pointed out, you can raise this issue at the trial before the trial court.
Absolutely. No, so why I've pointed this out is because I've raised these issues before the trial court as well. When I moved the first or third bail application, but the trial court was of the opinion that these lapses which have been made do not prejudice the accused. Now, what I'm trying to say is that they do prejudice the accused, and they've been numerous judgments as well, so which I'll be placing. One is authored by your good self as well, by your honourable self. So I'll be placing those as well. Do material prejudice make out a case for bail for the accused? They do. So I'm going in that line, Your Lordship. Now, what has happened is Section 29 was added to the charge sheet. So they have shown me as a co-conspirator. So all those things, okay, we'll examine during the stage of evidence.
Yes,
that's all right.
course.
But with regards to technicalities, those won't change, Your Lordship. What mistake has been made, those would not change. Hence, I'm going into these aspects. I believe it is mandatory because NDPS is a technical act. If I may,
please continue.
So Rule 10 I have read out. Your Honour is also aware that standing orders of 1 by 88 and 89 said that samples must be drawn from all containers. In this instant case, 70 containers were seized, but as I said, the contents were transferred into one plastic, and that same plastic was placed before the magistrate wherefrom the samples were drawn. Relevance to that, Your Lordship, can be found in the Panchnama, which is at page 44. I beg your pardon, Your Lordship, it will be page 48, Your Lordship, the typed copy of the Panchnama.
Yes.
Let me take you straight away to page 49, Your Lordship, the second page of the punch line. The second page. Sorry. Okay, so the second page says, the second paragraph, Your Lordship.
Yes.
At around 7 p.m., weight and measurement of the suspected contraband was conducted using electronic weighing weighing machine in the presence of witnesses and gazetted officer and accused person. One empty polythene bag was weighed and the weight is 17 grams. Suspected contraband were emptied from the soup boxes into the polythene bag and weighed. The weight of the suspected contraband is 732 grams and after subtraction of the weight of the polythene bag. Weight and measurement certificate were prepared and duly signed by the witnesses. The next paragraph. At around 7:20 p.m., preliminary test was conducted on the suspected contraband. A pinch of the suspected contraband was taken and placed it on the testing plate and added 1 drop of reagent and 3 drops of reagent 2. I believe actually we can stop here, Your Lordship. This is clear enough that the contents were transferred into one polythene bag, and I've already read out paragraph 15 of the charge sheet, which talks about the sampling process. Therein, it has been stated that one empty polythene bag was placed before the magistrate wherefrom the samples were drawn. So Rule 10 has also been violated. Your order has also authored in judgment in that line that sampling rules must be complied with and non-compliance prejudices the accused. Now, besides the non-compliance of the sampling rules of 2022, Section 52A has also been flouted in the instant case, Your Lordship. Now, in order to assert as to which particular aspect of 52 has been flouted, I'll have to read Section 52 of the NDPS Act, Your Lordship. Okay. Okay. So if you can go to... sorry.
Yes, please.
The relevance can be found in Section 52A, subsection 2. Shall I start reading?
52A?
Subsection 2.
52 subsection 2?
I'll start reading.
There's no A here.
No, there is not. No, 52A, subsection 2.
52A?
Yeah, yes, Your Lordship. Section 52A, subsection 2.
Okay, yes. 52A, yes. Please.
I'll start reading. 52A, Section 52A, subsection 2. Where any narcotic drugs, psychotropic substances, controlled substances, or conveyances have been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under Section 53. Your Lordship, this officer empowered would be the investigating officer. The officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to the description, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, or conveyances in any proceeding under this act, and make an application. So therein is the part which has been flouted, and make an application to any magistrate for the purpose of A, certifying the correctness of the inventory so prepared, B, taking in the presence of such magistrate photographs of drugs or substances or conveyances and certifying such photographs, and C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. Now, Your Lordship, I've read paragraph 15, so it seems that the samples were indeed drawn in front of the magistrate, but the certification part is missing, which is necessary. And why is it necessary? For that, I'll have to read subsection 4. Notwithstanding anything contained in the Indian Evidence Act or the Code of Criminal Procedure, every court trying an offence under this act shall treat the inventory, the photographs of narcotic drugs, psychotropic substances, and controlled substances or conveyances, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offence. So it's only upon certification does the seizure become primary evidence. Now that has been reiterated again and again, starting from the year 2016. I'll be placing the judgments as well. Even last year, 2 judgments were passed by the Honorable Apex Court, which said certification is mandatory, and in the absence of such certificate, there is no primary evidence. So these two, the sampling rules of 2022 and Section 52A has been flouted. Now, in order to assert, Your Lordship, that Section 52 has been flouted, I would like to take Your Honor's attention to page 50 of the petition.
Yes.
Okay. Page 50 of the petition, Your Lordship. Okay, so page 50 of the petition, it seems if you read the heading, it is an inventory report. So what can be assumed is probably this is the certificate which the magistrate had issued. But if we continue reading the items mentioned in the certificate, I'll start reading. So item number 1, orange whitish powder. That is the total powder which was seized. Number 2, 70 soap boxes. Number 3, 1 tin box. Number 4, 1 Maruti Alto. Number 5, 1 Oppo phone. Number 6, 1 Itel phone. Number 7, 1 Oppo phone. And finally, on the last page, Your Honor will find, oh sorry, there are 2 more items. 1 keypad phone at item number 8. And finally, item number 9, 1 driving license. And the last page, Your Lordship, is basically the ending part. I've taken you through all the contents of the list of the inventory. There's no mention of the list of samples in this particular certificate. And I would also like to draw Your Honor's attention to the last portion, signature, name and designation of the magistrate. And Your Lordship, I've verified this from the original certificate in the courtroom. It has not been signed by the magistrate. It seems they just prepared a pro forma format or a pro forma inventory report, but they never got it certified by the magistrate. I've checked it from the original in the court, Your Lordship. So nonetheless, even if this certificate was signed by the magistrate, it would still have implied non-compliance of section 52A. Why? Because under section 52A, it is mandatory or incumbent upon the investigating officer to get the list of inventory certified and the list of samples certified. And this particular list which we have before us does not contain the list of samples. Nonetheless, it has not been signed. So they just prepared the pro forma report, but did not comply with section 52A of the NDPS Act. Besides this, Your Lordship, these are all technical aspects, but the accused also suffers from a number of ailments. He suffers from hepatitis C, ulcerative colitis, which is basically colonal ulcer, and he also suffers from psychiatric disorders. Your Honor, I would like to take Your Honor's attention to page 55 of the petition. Page 55, Your Lordship. So page 55, if you go to page 55, which is annexure 12, it's a medical report of the accused. At the very bottom, Your Lordship, you'll find that the impression which is shown is borderline hepatic steatosis, which is hepatitis. Next, at page 56, Your Lordship, you will find again the impression is ulcerative colitis, which is basically colonal ulcer. And I must assert also here, Your Lordship, if this is untreated, it also becomes cancerous in certain circumstances, in certain cases. And perhaps the most important document, Your Lordship, is the next one, which is page 57. Now this I obtained from the court, Your Lordship. He was admitted to the civil hospital while in custody. If Your Lordship sees the portion which reads diagnosis on the left-hand corner, I hope it's legible, Your Lordship. Left-hand corner, diagnosis.
Final diagnosis?
Correct, Your Lordship. So that says major depressive disorder, MDD, with suicidal ideation. So this individual, Your Lordship, he also has suicidal thoughts and suicidal ideations. Your Lordship, one more thing. Now this application has been pending for quite some time, and that was because we were determining whether BNSS or CRPC would follow. And during this particular period, during the pendency of the bail application, the accused had to be taken to the civil hospital twice by the jail authorities. I have brought his medical papers on record through affidavits, Your Lordship. Your Honor will find them, I believe, as well. It's already been placed on record. So he had to be taken to the hospital twice. Once on the 26th of July 2024. I brought that medical on record through an affidavit dated 1st of August 2024. Are we there, Lordship?
Yes, yes.
Okay, so I'll take you to annexure 1 of the affidavit dated. I have already filed it, I verified it's there. Anyway, we can use it together. Because it is only upon they receive it, sir, that they allow filing up in the judicial section. Okay. So, Your Lordship, I'll continue reading from annexure 1. This is during the period the bail application was pending. He had to be taken to the hospital, and he was again diagnosed with major depressive disorder, as is clearly written on the top, Your Lordship. Major depressive disorder and suicidal thoughts. Thereafter, you'll find an entry, Your Lordship, which says suicidal ideation. And the diagnosis, Your Lordship, or the advice which was given to the patient is at page 2. Advice number 1.
Page 2?
Page 2, I'm sorry, the continuation of this particular annexure.
This is marked page 5.
All right, Your Lordship. It must be page 5. I'm sorry. The continuation of the...
See, this is the only annexure that you have annexed.
Your Lordship, you on which... is it the affidavit dated 1st of August? Or? Because I had filed 2 affidavits. He had to be taken to the hospital twice. That is why.
This is a 19.
Okay. I was talking about the medical brought on record through the affidavit dated 1st August.
Okay, page 2.
Right, Your Lordship. This is the affidavit dated 1st of August.
Yes. Yes.
Affidavit dated 1st August. He was taken to the hospital on the 26th of July 2024 during the pendency of the bail application, Your Lordship. He was taken to the psychiatrist and the psychiatrist advised, are we there, Your Lordship? Advice number 1. As patient still having suicidal ideation, so patient needs strong family support to prevent further deterioration. So that was the advice which was given to the accused in this incident case as he suffers from suicidal thoughts, that he needs strong family support. Your Lordship, just behind that particular page, you will find another medical document. This is from Super K Hospital. Now, what had happened, Your Lordship, is during this custody period. Are we there, Your Lordship?
Yes, yes.
Okay. So, what had happened during the custody period, because he suffers from a number of ailments, he made a complaint to his mother because the ulcer problem was aggravating. So his mother went to the doctor who was treating him in Super K Hospital, and his medicines had to be changed. Of course, this was not, he was not taken there through the police, but this is just his mother making an attempt to get to the doctor and ask why is he not improving. So the doctor advised fresh medication. Thereafter, Your Lordship, he had to be hospitalized again. And I've brought that medical again on record through an affidavit dated 19th of August.
Yes.
Right, Your Lordship. If you can go to the annexure, Your Lordship, which will be at page 4. Now again, this medical document is from the 9th of August 2000.
Yes. Page 4 of...
Your Lordship?
Page 5 or 4?
4, Your Lordship. The first page of the medical document.
That is page 5.
All right.
Your
page 5.
4 is your verification.
All right, Your Lordship. Sorry, I apologize.
Yes.
So, again, this is during the pendency of the bail application. He was taken to psychiatric ward, which is apparent from a reading of the heading, which says, case of MDD and suicidal thoughts on medication. Thereafter, he complained about the ulcer, and he was taken to the specialist doctor who treats ulcers. And if you can see, Your Lordship, on the left-hand corner of that very page, the doctor has advised him to go to CSC Vellore for treatment. That's all, Your Lordship. So on these accounts, since there have been procedural lapses, etc., and also because of his medical condition, I pray for him to be granted bail. But to buttress my arguments, I would like to place a few judgments, of course, before your good self. Lordship, the total number of 8 judgments in this. The total number of 8 judgments. So I've started by placing a judgment of the Honorable Apex Court passed last year in Simranjit Singh versus State of Punjab. I'll take you straight to paragraph 8, Your Lordship, of this particular judgment.
Yes.
All right. Paragraph 8. So in paragraph 8, the Apex Court reiterates the stand taken by the Apex Court in Mohan Lal's case. I've highlighted the portion.
Yeah.
Okay. So in paragraph 8, it reiterates that fact. Paragraph 15, I'll start reading from. So the paragraph 15 is from Mohan Lal's case. It says, it is manifest from section 52A that upon seizure of the contraband, the same has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under section 53 who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for the purpose of certifying the correctness of the inventory, certifying the photographs of such drugs or substances taken before the magistrate as true, and C, to draw representative samples in the presence of magistrate and certifying the correctness of the list of samples so drawn. And the very next paragraph, Your Lordship, again. Subsection 3 of section 52A requires that the magistrate shall as soon as may be allow the application. This implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned is in law-bound duty to approach the magistrate for the purpose mentioned above, including grant of permission to draw representative sample in his presence, which samples will then be enlisted, which has not been done. I've already taken your Honor's attention to that. Which samples will then be enlisted, and the correctness of the list of samples so drawn certified by the magistrate. In other words, the process of drawing samples has to be done in the presence of the magistrate and under the supervision of the magistrate, and the entire exercise has to be certified by him to be correct. This has not been done, Your Lordship. And I have also placed after this another judgment passed by the Apex Court again.
On the same point?
On the same point.
Not necessarily to quote so many judgments.
All right, Your Lordship. But one relevant paragraph, if I may quote from the particular judgment. Just one relevant paragraph.
From which judgment?
The second one, Your Lordship. It's Muhammad Yusuf.
Yes.
Muhammad Yusuf alias Hafiz. I've arranged in a manner in which I would be referring to them.
Yes, please.
Yes, Your Lordship. Right, Your Lordship. I'll read paragraph 15 and 16 only. Again, reiteration of Mohanlal's judgment. Paragraph 15 and 16 only, Your Lordship. Just take 2 minutes.
It's not required.
All right, sir. No, what this particular through this particular judgment, what has been stated is that trial is vitiated because of non-compliance 50.
Again, we are not.
Correct.
Let's not proceed to that extent.
I'll stop there.
We are not yet at the stage of the actual trial.
No, what was my endeavor was to bring the Honourable Court's notice that 52 is mandatory provision of NDPS.
Yes, what you're trying to imply here is the technical aspect of the matter has not been taken care of.
Absolutely.
Which has prejudiced you.
Okay. Maybe on that point it's fine, Your Lordship. Because 52 is a mandatory provision, mandatory provision. I wanted to reiterate that. That's so.
Even so, as I said, you would have a case before the in course of trial.
Now, Your Lordship, now that I've brought out to your Honour's attention that 52A has been flouted in the instant case and so have sampling rules, would that entitle the accused to bail? And would that prejudice the accused? Yes, it would. I have placed 3 judgments as well, in sequence, of course, which basically state the same point. And they all are matters of commercial quantity. So the first one would be, Your Lordship, Vimal Rajput. This was passed by the Honourable High Court of Allahabad.
Yeah.
I'll take you to paragraph 39. Paragraph 39 is at page 16, Your Lordship.
Yes.
Okay. So basically in paragraph 9, again section 52 is reiterated. Paragraph 40, Your Lordship, again reiteration of the sampling rules which I've already read out.
Yes.
Okay, and the observation starts from paragraph 46. I'll not take more than 20 seconds to read out, Your Lordship. Paragraph 46.
Yes.
Okay. So this was basically the same contention was raised before the Allahabad High Court as well, and what it came to observe was, from a perusal of the avertments made in the recovery memo, it appears that the packets recovered were not numbered serially for the purpose of identification, as provided in Rule 3.2 of the 2022 rules. The samples were not drawn, although this is not our case. It was drawn, as provided in Section 52A of the NDPS Act and Rule 9 of 2022 rules. Although 14 packages are claimed to have been seized from the applicant, samples have not been drawn from all the packets, and a single sample has been drawn, that too not in duplicate. And thus, the authorities have violated Rule 10 of the 2022 rules. Thereafter, Your Lordship, a few judgments are quoted wherein the Supreme Court has reiterated that if something is to be done in a particular manner, it must be done in a particular manner. Baldev Singh, etc., etc. And finally, in paragraph 49, Your Lordship, it's the Honourable Allahabad High Court holds. In the present case, it is evident that the authorities themselves have violated the mandatory provision contained in Rule 2022. So is our case. In the manner detailed in the preceding paragraphs, and prima facie, it appears that the aforesaid violation of the rules of 2022 will be a strong factor against the accused person being held guilty. Keeping in view the aforesaid facts, coupled with the fact that the applicant has no previous criminal history and he is languishing in jail since 28th of January 2024, and no materials have been placed with the counter affidavit to establish that there is a reason to apprehend that in case the applicant is released on bail, he would again indulge in commission of similar offence, I am of the view that he should be enlarged on bail. But the bone of contention, Your Lordship, was the same. Similarly, Your Lordship, another ruling on the same line passed by the High Court of Kerala. Relevance can be drawn at paragraph 4.
Yes.
So paragraph 4, Your Lordship, the same contention was raised. I will not get to all those aspects. I'll just get to the observation part because the same contentions were raised. Paragraph 4, that sir, 52A has not been complied with, the sampling rules have not been complied with, etc., etc., etc. And finally, the observation, Your Lordship, starts from paragraph 24.
Yes.
Paragraph 24, I'll read. It may be true that in the present case, when the quantity of the contraband allegedly seized from the accused is added, it will fall within the ambit of commercial quantity, as specified in serial number such and such of the Narcotic Drugs and Substances Act, etc., and consequently the rigor under Section 37 of the Act will apply. Section 37 Act stipulates that basically a person who's involved under commercial quantity shall not be released, and it states basically, Your Honor, it quotes Section 37 of the NDPS Act. Then, Your Lordship, in paragraph 27, it quotes a judgment of the Honorable Apex Court. In Dheeraj Kumar Shukla versus State, the Honorable Supreme Court has held that the second limb under Section 37 of the NDPS Act can be diluted if the accused has no criminal antecedents. The second limb, Your Honor, is that the court must be prima facie satisfied that he is not guilty. So that limb, it can be diluted if the accused has no criminal antecedents. That is also what I want to assert upon, Your Honor. This is his first case. He has no criminal antecedents. Let me continue reading, Your Lordship. On an overall conspectus of the facts, rival submissions made across the bar, the law referred to the aforementioned judgment and my findings rendered above, particularly regarding the infraction of the statutory provision by the detecting officer, which has obviously caused prejudice to the petitioner, and on comprehending the fact that petitioner has no criminal antecedents, I find that there are reasonable grounds to hold that the petitioner has not committed the alleged offence and is not likely to commit the offence. Therefore, the rigor under Section 37 of the NDPS Act stands diluted and the petitioner is entitled to be released on bail. Your Lordship, if you remember the previous judgment which I had read, therein samples were not drawn in the presence of a magistrate, but in this particular case, the samples were indeed drawn before the magistrate. Same situation. Contents were transferred from the plastic bag into one plastic bag, and the same plastic bag was placed before the magistrate. Same, exactly like us. But I didn't go into all that because I would be consuming a lot of your time, Your Lordship, but the same, exactly same situation. Thereafter, Your Lordship, there is another judgment passed by the Honorable High Court of Delhi. Same again, same situation again. Contrabands were transferred into one packet. The same packet was placed before the magistrate for the purpose of drawing samples. And the observation, Your Lordship, is it starts from paragraph 8. It starts from paragraph 8. May I?
Yes.
Okay. I am of the view that as mandated by the Honorable Supreme Court in Judgment of Union of India versus Bal Mukund and others, 2009-12 SEC 161, Standing Order 1/88 has been opined to be a requirement of law. The three-judge bench of Bal Mukund is binding on this court. Relevant portion of the Standing Order 1/88 is read as under.
Yes.
Rule 2.4. In the case of seizure of a single packet stroke container, one sample in duplicate shall be drawn. Normally, it is advisable to draw one sample in duplicate from each container stroke packet in the case of seizure of more than one package or containers. The Standing Order 1/88 mandates that the transferring of packets, the Standing Order of 1/88 mandates that the transferring of contents of all packets into one and then drawing a sample from the mixture is not permitted. I am of the view that in the present case, the instructions in 1/88 has not been followed and the sample has been drawn after mixing the contents of various packets into one container. The same has caused serious prejudice to the case of the applicant. Since the collection of the sample itself is faulty, the rigors of Section 37 of the NDPS Act will not be applicable. The applicant is in custody since 26 February 2022, has no criminal antecedents, and hence he was granted bail. in similar lines, Your Lordship. Now, again, Your Lordship, I must assert that this also was a case of commercial quantity. That is why they discuss Section 37. Lordship, thereafter is a judgment authored by your Honourable self. So, I'll just read paragraph 17 and 16 from the same. Sorry, I'll just read paragraph 7 from the said judgment, Your Lordship. From the above, what could be understood is that the alleged heroin was initially found in 4 containers. However, the contents of all the 4 containers were deposited into one transparent bag, Exhibit A, from which a sample is taken for testing, which according to the preliminary test report would show that the sample is positive for heroin. Thereafter, in paragraph 16, Your Honour observes, paragraph 16, Your Lordship. It is to be noted that out of the 9 witnesses cited by the prosecution, 6 of them have been examined, and as such, the case is at the fag end of its conclusion. It is too premature at this point to say as to whether the accused is innocent or guilty of the offence charged against him. However, on the contention of the learned counsel for the petitioner that because of a breach as far as the process of sampling of the seized contraband substance is concerned, wherein the standing order referred to herein above has not been complied with in its entirety, the issue is subjected to scrutiny before the trial court. However, prima facie, it appears that there has occurred such irregularity which has caused prejudice to the accused person. Then Your Honour refers to another judgment and proceeds to grant the accused person bail because of non-compliance of the sampling rules, Your Lordship. So is the case in ours. I mean, the case which we're dealing with. The only difference, Your Lordship, is that therein you spoke of the standing order 1/88, but now the case, because it commenced after December 2022, the sampling rules of 2022 are applicable, but the sampling process is paramateria or in consonance exactly similar, that contents have to be taken from all the packets. That is all, Your Lordship. Besides that, Your Lordship, for the purpose of Section 37, I place another judgment of the Honourable Apex Court for Section 37. And the relevant portion, Your Lordship, is at paragraph 19.
Where is it?
It's there. It's after your Honourable judgment. Muhammad Muslim.
Yes.
Muhammad Muslim. Again, this was passed in the month of March 2023. Now, with regards to Section 37 as to how a court should deal with an application,
Yeah.
a certain, let's just say, a guideline was provided, which is at paragraph 19 and 20.
Yes.
All right, I'll continue to read. Sure. May I continue? Paragraph 19. Paragraph 19. I've highlighted the relevant portion. Paragraph 19. A plain and literal interpretation of the conditions under Section 37, that is, the court should be satisfied that the accused is not guilty and would not commit any offence, would effectively exclude grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. Therefore, the only manner in which such special conditions as enacted under Section 37 can be construed within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the materials on record whenever the bail application is made. Whenever the bail application is made, I'm stressing on that the accused is not guilty. Any other interpretation would result in complete denial of the bail to a person accused of an offence such as those enacted under Section 37 of the NDPS Act. Paragraph 20. The standard to be considered, therefore, is one where the court would look at the material in a broad manner and reasonably see whether the accused person's guilt may be proved. The judgment of this courts have therefore emphasized that the satisfaction which courts are expected to record, that is, the accused may not be guilty, is only prima facie based on a reasonable reading which does not call for meticulous examination of the materials collected during the investigation. Let us stop there, Your Lordship, because after that, there's also discussion about delay in trial, etc. But I'm confining to these two because it's beautifully describes as to how a bail application under 37 should be determined. So when we look at the materials on record, Your Lordship, as the judgment says, what do we find? We find that the mandatory provision of the NDPS Act, which is 52A, has been flouted. We find that sampling rules have been flouted. So, Your Honour, it is safe for us to come to conclude there is a very good chance that this case would end up in an acquittal. I mean, that is what this paragraph 18 and 19 speak about. So a privacy look at the material shows that mandatory provisions of the NDPS Act have been flouted. As such, Section 37 can be diluted. And I've also placed the other judgments also, as well before that, Your Lordship. Lordship had also one last judgment, of course. I had taken your attention to the fact that the accused is a patient of, is a psychological patient and suffers from major depressive disorder. And that he has suicidal ideations. Now, in similar lines, Your Lordship, our ex-Chief Justice, Chief Justice Mir, had granted bail to an accused, of course, in a case of murder,
Yes.
but in similar lines. I hope it's placed before Your Lordship. I'll take you to paragraph 5. Paragraph 5, Your Lordship.
Yes.
It is right that when a person is involved for a commission of murder or any other offence carrying capital punishment, he is not to be released on bail under Section 437 CRPC. However, proviso to Section 437 CRPC carves out 3 exceptions. Number 1, if a person is under the age of 16 years. Number 2 is a woman. And number 3 is sick or infirm.
This is well settled.
Absolutely.
On the ground of sickness, bail can always be granted.
No, it's
You have this proof.
absolutely, Your Worship. But he had a similar psychological disorder. And Honorable Chief Justice was pleased to also observe in this that it is only when he's released would his condition improve. And it is only then that the trial would continue. This was also held in this particular judgment. Because if we lose the accused in custody, there would be no trial. And I had also taken your attention that he has suicidal ideations, Your Lordship. As such, on these grounds, I humbly pray for him to be released.
Yes.
My Lord, before I begin, 2 numbers of affidavits were filed here in this case, bringing into record the medical certificates and all. At least courtesy demands that it should have been served to me, my Lord. That was never served to me. Be that as it may, my Lord.
Yes,
I'm
sir.
coming to
Lordship, on that point, I would just like to state that before we actually take it to the registry upstairs, they mandate that we file it in the room which is downstairs with a copy for them. And that was, and it is only after a copy is taken on the notice, we are allowed to file it.
My Lord, from the day one, when the petition was filed, my friend was well aware that I was appearing in this matter. He could courtesy, at least he should have given to me personally. Now I have been suddenly, my Lord, attacked with this. But be that as it may, my Lord, I'll carry on, my Lord. Please, you're done? No. Are you done?
This one?
No, I'm done. Please. My Lord, before I counter the submissions made by my friends, which are basically, my Lord, firstly is hyper-technical, secondly on the ground of medical, my Lord. Before I come to that, my Lord, now I'll take your lordships to page 33 of the petition. That is the charge sheet, my Lord.
Yes.
My Lord, after going through this,
Yes.
it is to be noted, my Lord, through source information, my Lord, information was received to the effect that 3 persons, my Lord, they were in the process of, my Lord, dealing with huge quantity of drugs, my Lord. And my Lord is aware, my Lord, Meghalaya particularly, after the Manipur, my Lord, incident, my Lord, now the corridor of Meghalaya has been used, my Lord. So drugs is rampant in Meghalaya, my Lord. Now here, my Lord, through source information, these 3 persons, my Lord, as per the information, my Lord, they were in the process of carrying out huge drugs cartel, my Lord. So, my Lord, a NACA was being conducted, and the present petitioner, along with another co-accused, was apprehended in a separate car. And these 2 accused persons, when interrogated, my Lord, they were first unwilling to divulge the information. Subsequently, my Lord, when they were put separately, each of them, in a very identical fashion, my Lord, they revealed that the 3rd person is moving towards Guwahati. And this 3rd person is also nabbed, my Lord. It is dead of the night, next morning with the help of dog squad, my Lord. As per the, my Lord, revelation of these 3 co-accused individually, my Lord, they pointed to the same location where the drugs cartel was being hidden, my Lord. In the my Lord, farmhouse of one of the co-accused uncle, my Lord. So, my Lord, with the help of this dog squad, it was recovered. And the quantity is more than 700, my Lord, grams, my Lord. So, therefore, my Lord, so this is the nature how my lord, it was being. Now, throughout the submission of my friends, my lord, one thing he has not denied is the seizure, my lord. Nowhere. He is not denying the seizure, my lord. That has to be kept into mind. At this. Now, secondly, my lord, my friend has first raised the bypassing of the sampling rules of 2022, my lord. This present case, my lord, is in the verge of, my lord, framing of charge, my lord.
Yes.
So, my friend can agitate the matters at the time of argument before charge, my lord. So, this is premature at this moment, this kind of technical objection, my lord. Secondly, my lord, the initial medical certificate that was enclosed with the petition, it speaks of, my lord, because I am in possession of only that, my lord. That is at page 55. It is called as, the impression is borderline hepatic steatosis. My lord, it sounds very serious when it is in, my lord, medical term, my lord. But the common English interpretation is fatty liver, my lord. This is a case of fatty liver. 60% of the population of Indian population suffers of fatty liver, normal people, my lord. So far, my friend has been harping on, my lord, the psychological condition, my lord. It is only understood, my lord. We can well understand when a person is inside a jail, that too for a heinous offense like this, my lord, they are bound to have some sort of mental this thing. And our state, my lord, has got number of, my lord, institutions, hospitals, where we can treat them effectively, my lord. If it is a case of societal, my lord, then, my lord, my case is more easy, because a person inside the jail, my lord, and under the institution, under the care of the, my lord, protection of the police, my lord, there is less chance of committing suicide or deterioration, my lord. If it is outside, my lord, then it will aggravate the situation, my lord. Secondly, my lord, whatever my learned friend has cited the judgments, my lord, after all, at the end of the day, my lord, bail is a discretion, my lord. Different high courts of the country, my lord, has rendered, my lord, conflicting orders of, my lord, bail. However, my lord, to, my lord, sum up my submission, my lord, the latest judgment rendered by my lord, that is of 19 of this month, 19 September 2024. My case is squarely covered by this order, my lord. The only difference between the present petition and the judgment rendered on 19 September 2024 is that, my lord, the present petitioner's case is more aggravated, my lord. This is a case where, my lord, though the quantity was commercial, but the petitioner before your lordship for bail was, my lord, charged only under section 29, my lord. Only section. But, my lord, his wife was arrested, and through the, my lord, the CDR, my lord, call record details, my lord. So that way, my lord, he was made, my lord, charged under the particular section. And, my lord, so, and the present petition herein, my lord, my friend has, my lord, not whispered a single word denying the seizure, my lord. So I leave it to your lordship, my lord, and I am also providing the judgment. So I humbly pray, my lord, that the petitioner at this juncture may be advised to approach the court below and agitate the matter during the argument before charge.
Lordship, there's a few rebuttals on 2 points. It will not take long. So I said that I never denied that about the season. Before I started submitting, I was clean about every aspect, your lordship. Your lordship even asked me as to from whom the seizure was made, and I had categorically mentioned that it was made from the farmhouse of the co-accused. After stating that, your lordship, I had said that the NDPS Act is a technical act. Compliance of mandatory provisions of the law is a mandate. And basically, I confined my submission to the non-compliance of the mandatory provisions of the NDPS Act. So has also said that it can be dealt with at the stage of trial. I've read paragraph 19 and paragraph 19 of the Muhammad Muslim judgment, wherein the Supreme Court has said that when the matter is placed before a presiding officer, the materials on record must be looked into. Now, when we look into the materials of record, what do we find, Your Lordship? We find that prejudice indeed has been caused to the accused. Why? Because mandatory provisions of the NDPS Act have been flouted, which inevitably lead us to conclude that it would be a case of acquit. I am not going into the other facets.
Anyway, the fact remains, you would also admit that seizure has been made.
Seizure was made, definitely.
So, because you have gone into the aspect of the technical aspect of the matter as far as sampling is concerned, which means
absolutely
there is no dispute that it was of a commercial quantity.
Absolutely.
So,
anyway, on these lines, and there was a
I've
judgment
heard
authored.
the parties.
Right. Lordship, there's one more. Sorry, there's one more important facet. Sir, it stated there's one point that facilities are available to treat the patient. I took your honor's attention to the medical of the doctor himself, who has stated that he needs family help to avoid further deterioration, and the other doctor who was treating him for the ulcer has stated that he needs to go to Vellore. Nonetheless, the first doctor said that he needs family support. It's the doctors themselves, their doctors, who are stating that he needs family.
My lord, here is a case, my lord. A person is complaining of health and destroying the youth of the entire nation, my lord. That has to be, my lord. A balance has to be struck, my lord.
I'm not commenting on that anymore. It's a technical, like your lordship has already dealt with this. I'll take a leave, your lordship. Good.
Yes, what do we do? Next case? I've heard the parties.
Yes, lordship.
I'll have to go through your judgment. Otherwise, I could have passed the order here.
Troublesome, yes, lordship.
Item number 2.
Good day, your lordship.
May please, Your Lordship. Your Lordship, there are
Yes, Mr. Are you ready? Mr. Karola, you ready in this matter?
Because the arguing counsel is coming right now.
Mr. Nupio, ready?
Miss Dr. Mosika is leading this matter. Just left the premises, Lordship, for some difficulties. But it's their petition if they can start, Lordship. I have no difficulty here, Lordship. If they can start, Lordship.
You tell me, you want to start or you wait for them to respond?
Lordship, this has been going on for some time, Lordship. Even
They
after.
have a petitioner, Lordship. If they start,
If
either way, it'll take some time also.
If Lordship can pass an order today, that matter can be taken up ex parte without the.
Who can it be, Lordship? I'm
He's
here,
there.
Lordship.
What ex parte?
It's their petition, they're the petitioner, Lordship.
I've never heard of.
Never heard of such submissions, Lordship.
You're saying that in his face.
I'm not a shadow, I'm physically here.
No, Lordship. On certain occasions, Lordship, the matter has been adjourned later on after the arguments due to non-presence of the respondent, Lordship. As it becomes difficult.
We'll take up this matter next week then. On pre-made by the parties, this is matter after 2 weeks. Well, yeah, we'll take up the matter after vacation.
Obliged, Lordship.
Item number 8.
7 and 11, Lordship, they are both
Same.
matters.
7-11. Yes, you're saying?
Yes, Your Lordship, on behalf of respondent number 4 and 5, managing committee president and secretary, Your Lordship, I am withdrawing myself, and Your Lordship, I will please to issue notice to them.
Do you accept it?
Yes, petitioner can take fresh step on the rest. They are not contacting, not receiving my calls also, so it is not possible for me to make submission.
4 and 5 or 5 and 6?
4 and 5.
1 to 4 are state respondent.
4 and 5.
No, my lord, it is 1 to 4 is state, and 5 and 6.
5 and 6. Sorry.
Miss S. Study Learned Counsel has submitted that she is no longer appearing on behalf of the respondent 5 and 6. Mr. Learned Counsel, the petitioner, has submitted that fresh notice may be allowed to be issued on the said respondents. Pre-allowed, the notice be issued, let fresh notice be issued on the respondents 5 and 6 respectively. The same returnable within 2 weeks. List the matter thereafter.
Obliged, my lord.
Item number 10.
Auto kayo kang nandito sa supplement.
Yes. Maybe as Lordship, as per last order, we had to submit written submissions, Lordship. Lordship, may I place it on record?
What about the appellant?
Lordship, they've already filed, but
Yeah, but-
I don't see them today, Lordship.
Whether you would like to respond or
Lordship, this is written submissions, Lordship. We've already completed our arguments on the.
have you given them a copy?
Lordship, we'll give it written.
Mr. H. Karan, Leonard, Senior Additional G, has submitted that the written submission on behalf of the respondents is submitted today. None appears for the appellant. However, from records, it is seen that the appellant has already filed his written argument. Accordingly, this matter is now reserved for judgment.
Much obliged.
Second call from supplementary list. Item number 1.
My lord,
Let us not look at the time today because we have started late.
my lord, I'll just conclude. It will take only 2 minutes, my lord. I took some time to get it verified through the police, my lord. My lord, in such short time, you could not get it verified. What my investigating officer is saying is that these documents were not produced at the time of arrest, my lord. So I leave it to the discretion of this honorable court whether to consider them genuine. But these documents were not produced at the time of arrest.
But you see, Mr. Sengupta, what you
Absolutely, my lord.
see,
I have no.
What you are saying earlier is correct. In a sense that if the accused
Yes, my lord.
is an Indian citizen, he could not have been
Implicated under this
implicated under the
Foreigners Act.
So,
So that is what was very surprising, my lord.
so you see, in other words, it also means that if he is not to be implicated under the Foreigners Act, then bail. In fact, not only bail, he should not have been
implicated, arrested, or I bow down, my lord.
The IO should have filed a report that he is to be discharged.
True, my lord. So that will follow definitely, my lord. Since we have already forwarded the copy, my lord.
Unless and until he is, charged with some other
sections or
sections.
Absolutely, my lord.
Read with section 14.
My lord, am I audible, my lord?
Yes, Mr. Shila.
Yes, my lord. In fact, the section involved here is also for abetment, my lord, 14C. So it's not only for being a foreigner, but for abetting the coming of the foreigners, my lord. So perhaps in that line, I was. This issue was also raised at that time when we moved bail, my lord. This issue was also there. We have already placed those documents before the session court at that point of time. And from that time, they said that we'll investigate. Till now, also nothing is coming up, my lord. And perhaps, my lord, I will have not pressed so much if it's not for the death of my mother. Now my mother is no more. And I'm bringing things on record by way of affidavit. If something wrong is there, I can be booked under appropriate provisions of law. But just because they are having doubt and all, they cannot curtail my freedom, my lord. And especially, my lord, I need to come to reach my home to, at least if possible, to attend the funeral of my mother, which now with each passing moment, it's becoming very difficult, my lord. But at least I want to be with my family in this hour of bereavement. So let them carry out with the investigation. No issue will appear before them also, your lordship. Whatever condition your lordship puts will appear. It's not that we'll abscond, will appear before them also. Condition can be imposed to that effect. So, my lord.
Yes, about the parties.
Yes, my lord. Oblige.
Oblige.
Yes. Oblige.
My goodness.